video, I want to run down some of the key things to be aware of with the Renters Rights Act, and especially if you're an HMO a landlord or you're an HMO letting agent, what you should be thinking about and how you can prepare. I'm Wendy Whittaker-Large. I run Best Nest Properties, I'm an HMO landlord and I'm chair of the HMO Action Group. And we work to help landlords and tenants navigate the process of having a successful and profitable HMO, understanding the law as it applies to them and helping and supporting them navigate the changes in legislation. So today I want to share with you some of my key tips if you're an HMO landlord. Maybe if you're a tenant, this will also apply to you because these changes are fairly significant. In fact, I'd go to say that they're as significant as Section 24, the tax changes that George Osborne brought in 2015, maybe even the 1988 Landlord and Tenant Act, which was also a real shake-up in the private rental sector. The first thing to bear in mind is there's no transition period. When the 1st of May arrives, that's it. From 0001 on the day of the 1st of May, the Renters Rights Act will be law. There's no going back. If you haven't already served a Section 21 for a troublesome tenant or a tenant that you want to evict because you want the property back, it will be too late. You won't be able to do it. The 1st of May will have arrived and Section 21s will have been abolished. So this is the first tip. If you've got any tenants or any properties that you want to easily regain the possession of, you must issue the eviction notice before the 1st of May. That's critical. So I would suggest that right now you go through your list of tenancies, you go through all the different properties that you own and assess them thoroughly. Decide which ones are worth keeping and decide which ones you might want to do something else to, whether that's selling or using a different strategy to maximise the value of that particular property. But the one thing you cannot do is procrastinate. That will not help when on the 2nd of May you wake up and realise that it's too late to serve a Section 21. Because Section 21 is no longer going to be valid, this means that every tenancy will go from being an assured short-hold tenancy to being a periodic tenancy, and all tenancies will automatically convert into periodic tenancies. Now, as part of that process, the other new rule that has been brought in is that tenants have to give 2 months' notice if they wish to leave a property. So this is one for you if you're a tenant. Remember that 1 month's notice is not going to be sufficient. If you just give 1 month's notice to leave your property, it's likely that your deposit, if you've paid one, is going to be used in lieu of the 2nd month's notice that you're supposed to give. So make a note of that. And for letting agents and for landlords, please be aware that that 2 months' notice is written into law. So you are legally able to claim for a deposit where the tenant has not given you 2 months' notice and yet has still moved out of the property. There are changes, of course, that relate to student HMOs as well. And this particularly relates to ground 4A of the Section 8. From the 1st of May, the only way that you will be able to evict a tenant or change the details of that tenancy are going to be through the Section 8 process. So what that means for student landlords is that you will have to revert to ground 4A. This allows you to regain possession of the whole property during a specific window, the 1st of June and the 30th of September. But, and this is the really important deadline, to use ground 4A for your existing student tenancies, you must give your students a written statement by the 31st of May this year, confirming that their tenancy is one to which ground 4A applies. If you don't do that, you lose the right to use ground 4A for that tenancy. And ground 4A requires 4 months' notice. So even if you serve the statement on May the 1st, your notice won't expire until early September, which is cutting it very, very tight. So this is a real #1 action if you've got student HMOs. Make sure that your ground 4A statements are written up and prepared and ready to serve. Number 4, rent increases. Currently, you're able to give your tenants just over a month's notice to increase their rent. There's no form to fill in. You can simply send them a notice saying you wish to increase their rent. Now, many landlords are currently using a Section 13 notice to do this, but this will become law under the Renters Rights Act. So what that means is that you will have to give 2 months notice to a tenant. You'll have to use the Section 13 form, which you'll find on the government website, and you have to you're limited to doing this only once per year. So this means even more than ever, you need to have good systems in place. You need to have a diary that shows to you when that tenant moved in and when 9 months has elapsed from their tenancy, because in order to give them 2 months notice, you also perhaps need a little bit of wiggle room to make sure that you can actually implement the Section 13 form. You're going to fill out the form, send it to the tenant. If the tenant disputes it, there will actually be a small fee that the tenant has to pay. That was announced last week. Now, this may dissuade some tenants from challenging the rental increase, which is probably a good thing, but it will mean that there might be a period of negotiation that you have to go through with your tenant, in which case I would recommend that you start this process early. It also gives the tenant the opportunity to give notice if they decide they want to leave the room or the house, if they feel that the increase is too much, and it also allows you to justify why you've raised it to that level. Usually, in my experience, most landlords increase rent because their mortgage has gone up, their costs have increased, or there's some other justifiable reason, possibly because market rents have also increased around them. And these are all good reasons why you should make sure you've got a system in place to be able to analyse and put up those rents, not just on an ad hoc basis anymore, but on a much more systemised, diarised process. Now is also a really good time to look at the current rents that you're bringing in. Are some of your room rents perhaps a little bit below market level? Have you failed to increase them? Well, if you don't do this before the 1st of May, you're going to find yourself in an impossible situation where it's going to be difficult to increase them immediately because of the time lag, but also it's going to mean that you aren't in a systemised process. And if you want to make your business as effective and hands-free as possible, the more you systemize, the better it will be. Number 6, as of the 1st of May, any contractual obligation to pay rent in advance is null and void. Now, it doesn't mean to say that your tenant couldn't offer rent in advance. And I know for some tenants, this is the answer to possibly having a poor credit rating, not being able to have very good references, or not having a guarantor. Paying advanced rent can be the solution. But sadly, under the Renters Rights Act, this has been outlawed. So you are not allowed to ask for rent in advance, and this should not be a contractual obligation. However, if your tenant decides to offer you rent in advance, this will be allowed. So it's not something that I'm promoting for landlords and letting agents, but if you're a tenant and you've maybe got a little bit of a shaky credit history, or maybe you're worried about being able to get a property because your references are not particularly solid, this is one for you. You can offer to pay the rent in advance, and that might just swing it when it comes to getting the rental property of your choice. Number 7, guarantors. I'm a real big fan of guarantors because I think it really gives weight and resilience to a tenancy. If you're a tenant who perhaps doesn't have a lot of extra money, so you're living kind of month to month, you haven't got much savings, or by the way, that's something to think about. You should perhaps think about getting a savings account, start to put some money into that account on a monthly basis. But aside from that, if that's not where you are right now, and perhaps you're finding it hard to come up with a deposit, you might have to use an insurance-based scheme for the deposit. Nevertheless, if you have a guarantor, this is somebody who's going to guarantee your rent, even if you fail to be able to pay that rent. And for a lot of landlords and letting agents, this is a fantastic tool. And I do wish this was much more prevalent in the UK. Now, it's true to say we have a number of tenants who come to us looking for rooms or looking for properties, and either initially or long term, they can't find a guarantor. Now, that is a problem for them because in a supply market where supply is limited and demand seems to be exponential at the moment, those people who don't have guarantors are probably going to find themselves at the bottom of the list. So, tip, if you're a tenant, try and find somebody who would guarantee you. And in order to find a good guarantor, it might be a member of your family, it might be a close friend, it might be a work colleague, you're going to have to prove trustworthy. They're not going to want to guarantee somebody who isn't trustworthy. So have a think about how trustworthy you are and how you could convince somebody or persuade someone to be your guarantor. For landlords and letting agents, on the other hand, please think about using a guarantor system. At Best Nest, we use a guarantor system, and it is incredibly useful in reducing down bad debt. It's a method that we can use to deal with some of the tenant issues that we might sometimes find we come across, because having a guarantor is often a member of the family, and not only do they guarantee the rent, but they can sometimes act as a kind of arm around the shoulder to that tenant and try and encourage them and help them in their tenancy, and enable them perhaps to act in a more tenant-like manner. Number 8, the information sheet. So you will have seen last week that the government issued the information sheet that they wish all current tenants to receive who are in a letting property on the 1st of May 2026. So this is for all tenants who are currently in an assured short hold tenancy, or indeed where their AST has turned into a periodic tenancy, but prior to the 1st of May. This information sheet will be something that you as a landlord and or your letting agent will have to supply to the tenant. So if you're a landlord and your letting agent hasn't talked about the information sheet yet, make sure they understand that they also have to provide this to the tenant as well as you. It's belt and braces, people. Now, after the 1st of May, of course, all tenancies will be periodic. So this tenancy information sheet will no longer be relevant for new tenancies after the 1st of May. But make sure that for any current tenants, you've got that diarised and you know how you're going to send that and make it available to all your tenants. So I'm going to just give you a very quick reminder and a quick update on these tips and a summary of what we've talked about today. Number 1, review every tenancy in your portfolio. Know which are ASTs and which are periodic and how they will convert on the 1st of May. Number 2, check for any outstanding 21 notices or any that you want to issue before the 1st of May. You will have until the 31st of July to escalate these if they need to be escalated to court. Don't miss that backstop. Number 3, update your tenancy documents. From the 1st of May, they will all become periodic and they will all require a written statement of terms. In other words, a contract. Make sure you've got your templates ready. Make sure you know the terms and conditions listed in those contracts. Number 4, make sure you're working with a letting agent who also understands the rules and that you've got a system and a process in place to make sure that neither of you is missing some of these key issuances of information and also hard backstops. Everybody who's involved in the HMO, whether that is you as a landlord, your letting agent, and even tenants, need to understand the new rules coming in on the 1st of May. Number 5, review and adjust your rents. Do it now before May, because after the beginning of May, you'll only be able to do this via a Section 13 notice. Number 6, consider using guarantors. And if you want any more information on guarantors, please get in touch. I can help you with this. We use a specific format, a specific letter, and this runs alongside the tenancy to make sure that the guarantor process really works. By the 31st of May 2026, you have to serve the government's information sheet on all existing tenants. So you've got a month to do it. I would recommend you do it very quickly so you can know that it has been served and that everybody has received that. If you don't, there is a civil penalty of £7,000 for non-compliance. If you're a student HMO landlord, think about getting your Ground 4A written statements on all qualifying student tenants done. And if you currently only have a verbal tenancy agreement with your tenant, make sure that you've got a written statement and that is in place by the 31st of May. So this is really about getting your ducks in a row. It's about getting organised, it's getting it systemised. And maybe you might have thought, do you know what? I don't really want to be running my HMO anymore. I'd rather leave it to the experts. If this is a job that is taking up too much of your time, taking up too much of your emotional energy, I would recommend that you find an HMO letting agent. And in South Cheshire and North Staffordshire, we here at Best Nest are delighted to manage properties, whether you are a landlord of a single buy-to-let property or of an HMO. We know the rules, we know the regulations, we know how to keep you compliant. We also know how to fill your rooms and keep them filled so that you make profit and you have a profitable HMO portfolio. Thank you very much for listening today. If you've got any questions, please feel free to message me or put them in the chat panel below, and I'll do whatever I can to help you. Thank you so much.